suppose 2255H did include a specific provision that said you can't bring a successive 2255 motion based on an intervening statutory change. Would then there be a strong negative implication?
Yes, I think there would, because then we'd be in this third category. Like I've mentioned the three categories of federal habeas claims. One is about execution of the sentence. We're not really talking about that here. One is federal prisoner claims that have analogs to state claims, and I just described a little bit about how those might shake out. And then we're talking about a kind of claim, a statutory claim that's really unique to federal prisoners, and I think where Congress has expressly precluded it and clearly focused on it, then
right. I mean,
that would be a much more difficult case.
It's much more difficult,
yes.
And let me make sure I understand your answer. You would answer it the reverse way.
I think we probably would, yeah, Justice Kagan.
Yeah, and that's so even though it would refer only to 2255 motions and not to habeas. Right?
Yeah, I think our critical point here, Your Honor, isn't that 2255 can say nothing about the withdrawal of the federal habeas remedy. It's just that, as this court has stated in multiple recent cases like McQuiggan and Holland, it requires something of a clear statement or a bright light indicator to withdraw the federal habeas remedy. And I think you have that for the stuff that Congress clearly focused on, but we don't have that for the kinds of claims, the kinds of statutory claims that we're talking about here. Those are actually quite different from what Congress might have been thinking about, even in 2255F3, for example, which imposes a statute of limitations that doesn't include the word constitutional like 2244's does, where you can often have a claim based on a statutory right that is framed in constitutional terms. The kinds of rehaif claims we see on first 2255s aren't these kinds of statutory claims, which essentially are claims of actual innocence in merits form. What they are claims of an unknowing plea, mirroring what happened in Boozley, and they're claims about the jury instructions, which sound in the Sixth Amendment. So you've got Fifth and Sixth Amendment claims that can be based on a statutory right, and that might have been what Congress was thinking about.